Welcome, everybody. Good morning, good afternoon, good evening. Welcome to this APPI ACP webinar, Sustainable and IP Enforcement. This is the last of a series, the fourth webinar of a series of four, in which we have been discussing a very interesting topic about IP and climate change. On behalf of the First Deputy Reporter General of AIPPI, Ralph Knack, I want to express, first of all, my gratitude to all of you to take the time to be here and all the speakers and the team who has been possible to make this. This series was possible due to a deep understanding and fruitful cooperation between APPI and ACP. Our APPI remains fully committed with ACP to continue working together on this type of programs. During this year and under this general topic, IP and climate change, we have discussed very interesting and complex issues. The first one was green companies and IP new challenges. The second one, trends in IP protection of green technologies. The third one, positive impact of innovation on climate change. And indeed, today we will discuss sustainable IP enforcement. We have been successfully have very distinguished speakers from Colombia, Peru, from WIPO, and we have to recognize all their support. And today we have very good and experts on this issue. I just want to express my gratitude from the IP side to Ralph Knack, I already mentioned, to Leonor Magalhães Galván, and Marco Sardi. She's the chair of the IP Sustainability Committee, and Marco, the vice chair, who has the brain behind this to choose the topics and as well as the speakers. Also to Cinzia, Petrucello, and Elsa, who have been essential that this happens. From the ACP side, it's part of my heart, to the Executive Committee, of course, Luis Enriquez, Martín Pitaluga, Giselle Rubin, that she's here, of course, Jorge Allende, he's the head of or chair of the ACP Futuro Special Commission, because this was happened because of all of them, as well as WIPO, especially to Marco Mendez Alemán, Assistant General Director, who also was very supportive. So I'm very grateful to just say thank you, enjoy this webinar, and I pass the floor to Giselle. Giselle.
Muchas gracias, Martín. Muy buenos días a todos. En nombre de ACIPI y de nuestro comité ejecutivo, quisiera darles la más cordial bienvenida al webinar del día de hoy que estamos realizando con nuestra asociación hermana IPPI, a la luz de un convenio de cooperación que firmamos y pues que estamos poniendo en práctica. Este es el tercer año consecutivo en que hemos hecho una serie de 4 webinars conjuntos, todos de temas actuales. Entonces, realmente estamos muy contentos de esta cooperación. Este es un webinar muy especial porque es el cierre, como dijo Martín, de los 4 webinars que realizamos este año. Quisiera agradecer a Martín Michaus con su doble sombrero, a CPI-PPI, que ha propuesto y ha cooperado y coordinado muchísimo los webinars. Y quisiera también unirme al agradecimiento que ha hecho Martín a todo el equipo de ACIPI, a todo el equipo de IPPI, especialmente a Cintia y a Elsa, a Leonor, al Comité de Sostenibilidad, y también quisiera agradecer a todos los panelistas y moderadores que nos han regalado un rato de su tiempo y conocimiento para hacer posible estos webinars. Así que muchísimas gracias y le cedo la palabra a Leonor.
Gracias, Giselle. Thank you very much. It has been a pleasure to help organize this webinar series, and thank you, Martín, for being the brain behind the idea of this AAPPI-AZP partnership to discuss IP and climate change. As chair of the IP and Sustainability Standing Committee of AAPPI, it has been a pleasure, together with Marco Zardi, our vice chair, to help organize these panels. And this panel today is a panel that is very dear to our committee because it's something that we have been working on, and we intend to propose a study question for APPI. And it concerns the sustainable enforcement, and that is the sustainable destruction or reuse of counterfeited goods. Currently, they are destroyed usually by incineration, which poses a serious climate challenge. And so counterfeited goods are harming the environment, not only when they're being produced, because they're often produced in very questionable production factories, and then when they are destroyed, they're again harming the environment. And this is something that the world needs to address, and IP practitioners and IP owners need to think about in the future. So with that, I will pass the word to Jorge Allende, who is the moderator of this panel. Jorge is the president of the ASIPI Future Commission or Committee that is in charge of the contest Green Innovation for ASIPI. He was a past president of the Peruvian IP Association, and he's the founding partner of Allende and Garcia in Peru. So to you, Jorge, thank you for being the moderator of this panel.
Thank you very much, Leonor. Thank you very much to everybody that is joining us in this joint webinar APPI ASIPI. And with not more, I will introduce our panelists. Nuria Abella Mendez. Nuria is a manager of REACT Spain branch of the Dutch Anti-Counterfeiting Association since 2007. Nuria has worked as a lawyer since 1998. Initially, she started at Uría Mendez in Spain, and then she continued in Jacobi and Partners in Turin. Nuria has acquired extensive experience in coordinating anti-counterfeiting activities, as well as managing trademark portfolios and in legal procedures in defense of intellectual property rights. Currently, it has a very active role in the development of REACT Sustain project that has the goal of processing the confiscated goods through to destruction in a responsible, effective, and sustainable manner. Jan Jacobi. Jan is a Dutch attorney at law, practicing since 2013. After graduating from the University of Amsterdam, Jan is currently working at Barends Krans in The Hague, Netherlands, having previously worked in London and in Amsterdam. The focus of Jan's practice is on litigation of complex cross-border IP disputes within the area of trademark, copyrights, and design laws. He has been involved in several landmark cases before the European Court of Justice, but also regularly litigates before the UIPO, the Benelux Bureau of Intellectual Property, as well as the Dutch courts. Jan also publishes frequently on IP-related topics, and he also has a minor in philosophy. With not more, I will pass the word to Jan that will start with the seminar. I'm sorry. The housekeeping, we have the questions and answers box for after the speaker speaks. There will be a translation in English and Spanish, no Portuguese. And at the end, there will be a survey regarding the webinar. So now I pass it to Jan.
Okay, thank you so much. I will share my screen for the presentation. There we go. Thanks so much for introducing me. It's a pleasure to speak today on a very important topic, a topic that I will think will become even more important in the coming years. As Jorge said, I am a Dutch attorney at law. I have been working since 2013, and I work in The Hague, the Netherlands. My practice is on primarily litigation on trademarks, designs, and copyrights. And in my practice, I see a lot of interesting cases. When I started 10 years ago, the topic that we are discussing today was not really that relevant, I think. But more and more, especially in the last couple of years, we see that there is more emphasis on what can we do as IP practitioners to be more mindful of the climate, to have a more sustainable way of enforcing IP rights on behalf of the client. And in my presentation today, I will show you that although there is still a lot to do, a lot can already be done, but there are several quite complex questions that we need to address that are currently still very much unanswered. I would like to start my presentation with a very interesting case that occurred last year around the same month in November for a client that is a major manufacturer of miniature Christmas houses. These are very cute, tiny Christmas houses that you can put next to your Christmas tree or your Christmas chimney, and they really add something to the whole Christmas vibe. These are quite expensive because the client, the manufacturer, hand paints all of the figurines of the Christmas houses. And we discovered in November that there was a major party, a major retailer in the Netherlands that offered counterfeit models of these Christmas houses. We managed to get a seize order of the Court of The Hague, and then we successfully seized these products. And then afterwards, it turned out that there was a huge stock of these houses, around 200,000. Christmas miniature houses, they are a seasonal product, so they cannot be used in every season. So the question arose, then what should we do with these specific Christmas houses? And as I said, 10 years ago, this wouldn't have been such a difficult question. I think what you would have done was to destroy these houses because they do not serve a purpose and they are damaging to the client. But now, with the sustainability approach in mind, I had to advise my client on potential next steps. And if we go to the next slide, you will see that there was quite a difference in the quality level of both houses. On the left, you see the original figurine. You can see it's hand painted. And on the right, you can see the counterfeit model. And as you will see, the right one is obviously of an inferior quality. So that poses additional difficult questions. Will it be possible for the client to allow these to go back on the market under his own name, even though the quality is inferior? Can the chemicals be trusted that have been used to produce these products? What if the client is held liable for this product and doesn't know what's in the product itself, etc.? All of these difficult questions arose. And within the context of European law, the client has several remedies that it can invoke. And these remedies, they are provided for under the Enforcement Directive. It's applicable to the entire EU. And the Enforcement Directive stipulates in Article 10 that as one of the measures, the owner of an IP right can, if there is an infringing good, recall these goods from the channel of commerce, request the definitive removal from the channel of commerce, or choose for destruction of these goods, so the entire destruction of the goods. In paragraph 2 of Article 10, it is stated that these measures are at the expense of the infringer unless there are particular reasons why this should be different. And in paragraph 3, you have what I call the proportionality test. The measures must be weighed against the severity or the seriousness of the infringement and interest of the third parties. Now, the Enforcement Directive is already almost 20 years old. Yet, 2 years ago, there was a very interesting question, a very fundamental question on what the measure of destruction now actually means and how it can be used in practice. The case was ruled by the highest European Court, European Court of Justice, and it's called the Perfumesco case. And I will give a short background of the facts of the case. It's a Polish case, so it related to a Polish defendant, Perfumesco, who sold online several perfumes, and one of these perfumes were original perfumes that came from Hugo Boss. So they were not counterfeits. They were originally manufactured by Hugo Boss, and they were so-called testers. Those are test samples that are used to promote a certain product. Now, although they were genuine products, authentic products, they were not destined to be sold on the EU market. So Hugo Boss didn't want them to be on the EU market. They were not destined to be on the EU market as such. They had different quantities, and they also bore a very clear sticker that said not destined for EU sale, and a sticker that said tester. Also, the packaging in which these perfumes were sold was tampered with. I believe the original identification numbers were made invisible, so Hugo Boss couldn't see where the leak in its network came from. Interestingly, under Polish law, the claim for destruction only applied to counterfeit products. So products that are counterfeit, that infringe the rights of the right owner. And the national law did not allow for destruction of genuine products. So products that originate from the IP owner, but are not on the market where the IP owner wants to be. And then the Polish referring court was unsure whether this practice, whether this legislation was in accordance with the enforcement directive. The European Court of Justice, in reviewing this question, firstly recalls that Article 10 of the enforcement directive, which mentions the measure of destruction, is a transposition of Article 46 of TRIPS. And in that article, the measure of destruction is also mentioned, but it doesn't differentiate between types of infringement. So in other words, in Article 46 of TRIPS, there is no distinction being made between counterfeit products and authentic products. And then the Court of Justice proceeds and considers the principles of the enforcement directive and holds that these must be effective, they must be proportionate, and they must be dissuasive. So against that background, the measure of destruction must be considered. Furthermore, the enforcement directive provides for a minimum standard, which means that the member states may not provide for a less protective measure. And particularly the last point is of importance here, because if you were to allow that a certain member state only destroys goods that are counterfeited and not authentic goods, you will have diverging practices between each of the member states. And that is not what the enforcement directive aims to achieve. Therefore, the European Court of Justice concluded that the destruction is possible irrespective of the type of infringement. So in conclusion, if you have a counterfeit product or an authentic, genuine product, you can still request that these be destroyed, dependent on whether it's a proportionate measure and whether the interests of third parties have been weighed. So although this decision gave a lot of clarity, there are still some questions open, and those depend on what exactly do we mean with proportionality and what do we mean with the interest of third parties. And this is essentially left to the member states to decide on. Firstly, there is a complication because, as the European Court of Justice said, it is an implementation of Article 46 TRIPS. But Article 46 TRIPS says, when you consider an infringing good, that the mere debranding, so the removal of infringing signs, is not automatically possible for these goods for them to be released again in commercial trade. The European Court of Justice also confirmed this somewhat in another decision in the Mitsubishi case, where it said that debranding and rebranding may be use of a trademark as such. So that is not something that is automatically agreed upon by the trademark owner or something that it should automatically agree on. Then on the level of the severity of the infringement, I think there is a material difference between counterfeit goods, because there the good itself is infringing, and authentic, genuine goods. And with respect to the latter category, the good itself is not infringing, but the act that someone does with them, for instance, placing them on a market where the IP owner doesn't want them to be, that is what constitutes in the infringing act. There should be, I think, a material difference in how we regard these two different products. Furthermore, when you look at the severity of the infringement, what is the question of intent? You have, of course, a lot of parties that intentionally create counterfeit products, but you also have infringement cases which are more or less an accident, or where there is an infringement but it's not as strong as a counterfeit infringement. Should that have any weight when you assess the measure of destruction? Lastly, a very complex category are goods that are in transit, so which are detained at the level of customs, but which are not in the circulation of, in this case, the European Union, and they can go still to a third country where the right owner may not have any rights. Is it under those circumstances possible, and is it appropriate and proportionate if those goods are to be destroyed, if they can go to a very completely different country where there may not be any protection whatsoever? When you consider that these questions are essentially left to the member states of the EU, you sort of wonder, how does this relate to the impact of the enforcement directive and the minimum standard that the enforcement directive aims to achieve? Will there not be a situation when this topic becomes more and more relevant and more prominent, that you have some sort of forum shopping where an infringer thinks, well, in this member state, I do not risk when I'm caught, I do not risk that my goods are going to be destroyed. Even more so, in that member state, the judge will look whether it's possible that the rights owner and I, as an infringer, come to an agreement and I'm allowed to sell these products under a license agreement. Does it not mean that the practice of infringing somewhat becomes attractive if there is such a way out? When we look at the second requirement under the enforcement directive, where the measure of destruction has to be assessed against, it's the interest of third parties. So traditionally, of course, you have third parties, you have a claimant and you have a defendant, but are there also very completely other abstract third parties to consider? For instance, is the environment a third party? Are environmental concerns a third party? If so, it would mean that in practice you could allow environmental organizations to join an ongoing infringement case and say, well, we consider this claim for destruction to be disproportionate. Are there other prevailing interests other than the environment? I give the example of, for instance, you have an infringement case on semiconductors. As we know, these are very valuable, especially nowadays. And there is a claim to destroy large quantities of semiconductors that could be otherwise very helpful to a national economy. Could it be possible that, for instance, in such an example, the government interferes or another party interferes and says, well, we believe the destruction of such goods, even though if they are infringing, is disproportionate because they can serve a different purpose for our national economy? Lastly, and that's a very interesting and difficult question, who should make this argument? Is this an argument that the claimant, the IP holder, should make? Is it an argument that the defendant should make in trying to fend off a destruction claim? Is it something that a judge itself should examine ex officio? What these questions, I think, illustrate is that right now it is an issue of ownership. We do not know where this claim for destruction, who owns this. As a general rule, it's the IP owner who claims it, and if the claim for destruction is awarded, the costs are for the infringer. That sounds very simple, but in my practice, I see, for instance, often that an infringer is abroad, is anonymous, or it's a company that doesn't even exist, or is a company that does not have any assets. So even if they are ordered to pay for the destruction, most of the time, it's the IP owner who pays for it itself. And make no mistake, the cost for destruction can be quite significant. If you consider alternatives to destruction, then you have several difficult questions to answer, and probably these will be less attractive to the IP owner. For instance, if you allow products on the market again that are an infringement to your rights, that they have limited intrinsic value. Counterfeit product is often of less quality, inferior quality than the authentic product. It may harm, if you have it's a trademark infringement, it may harm your trademark, may result in trademark dilution, confusion on the market, etc. There is a question of harmful chemicals. Often these products, because they are cheaper, they have been produced by means of harmful chemicals. What happens if, for instance, the IP owner and the defendant, so the infringer, agree that these products are being sold on the market, but a product liability issue occurs? Does it mean that the IP owner has to carry those risks, or is it for the defendant? Those are difficult questions that you need to address. Lastly, if you even were to consider such an alternative measure to avoid pointless destruction, then it does assume that there is still some sort of good faith and trust possible. But let's consider the facts often in these cases, that you are dealing with an infringing party and you have lost all trust in them because they have copied your product. They have purposefully tried to infringe your rights. So how viable is it that you continue to essentially deal with these parties on the good faith, and you trust them that they will stick to contractual agreement, that they can sell the product under, for instance, a license agreement. I have included a quote of a friend of mine. It's not a famous person, but I think he will become quite famous. He is a cardiologist, and he did research on pacemakers. And I didn't know this, but apparently pacemakers are subject to rust as well. They can rust in the human body. And the medicine to avoid the process of rusting is very expensive. And Arnaud discovered that a medicine for gout, a very cheap over-the-counter medicine, is very effective, and it essentially slows down and avoids the process of rusting significantly. And in his PhD thesis, he had the quote, which I think is very applicable to this question as well: using the available to enable the sustainable. And I think that's a way that we should look at this question more. Traditionally, I think a lot of IP owners would think, I want to have the destruction of the goods because that solves my problem. The good is no longer on the market and I can continue my business. I never asked for this problem, so it's unfair that I should carry the consequences even more than I wanted to. But if we approach it from a different angle, namely, yes, this happened, there are infringing goods, some of them will be counterfeit, some of them will be authentic. Is it not better that instead of destruction, we look at alternatives? For instance, the alternatives that I mentioned, or you can think of upcycling, where a product is being incorporated in an entirely new product. You have several alternatives ready, but it depends on the willingness, of course, of the IP owner. But overall, merely going for destruction as a measure, I think, should be really reconsidered. Not in the last place because of the consequences for the climate. Then right now, it is still left essentially for the member states in the EU to deal with this specific question. We can ask ourselves, is that a solution that is sustainable for the future? Or should, at a certain point, a government step up, or even more preferably, the EU itself, by giving a recommendation on how these cases should be treated? Alternatively, you can think of other solutions as well. For instance, if an IP owner does not want to choose the remedy of destruction, that it can apply for a different scheme. Or if it does want to destroy the goods, it can apply for a scheme that these goods are being destroyed in a sustainable manner. As Nuria will discuss as well, these options are possible. And if it opts for such a choice, then it may get a discount in destroying those goods. What also can be considered in the EU, you obtain, when you win an infringement case, you obtain a cost order to compensate for your legal costs. One could also consider that instead of compensating your legal fees, if you are going for the claim for destruction, those fees should be directed at a sustainable way of destruction. So as you see, there are many questions still unanswered. It would be good, in my opinion, if there were some additional guidance on a more EU level. But at this point, as I said, many questions are still left unanswered. However, what we do see, and I would like to finish my presentation with this, is that at least for the Netherlands, courts are becoming more conscious of this question. And there is a very nice and recent example of the Court of Appeal of The Hague, which related to a Ferrari kit car. It was a car that originated from an original Chevrolet, and a company had made many alterations to the car and essentially made a Ferrari out of it. And in doing so, it made use of Ferrari logos, Ferrari trademarks, also some of the typical designs of Ferrari. And the Court of Appeal ruled that those acts as such were infringement. Of course, Ferrari claimed that these cars should be destroyed in their entirety, but the Court of Appeal said, no, that's a measure that I consider to be disproportionate. I cannot allow the destruction of the total car because it would be a pointless destruction of capital. It's not a proportionate measure because there are alternatives possible. And if we look at the alternatives that were reached in the end, I've included a translation of the final decision, is that the court says all the infringing parts of these cars, they have to be removed and destroyed, essentially stripped, and the parts that were not infringing, they can be returned to the defendant, to the infringing party in this instance. So when you look at what the court is ordering, I think it looks quite comical. It orders the destruction of the entire body frame, the lamps, the bumper, the mudguard, the rims, the chassis, and the steering wheel. I don't know what's left of the car after that, but it also says specifically that the remaining parts are to be returned to the vehicle, to the defendant. As I started this example with the miniature Christmas houses, I advised my client to look at all potential options. But in the end, because there were harmful chemicals used, it was very difficult to look at a sustainable alternative. Also because of the huge quantities, normally you could consider giving them to charity, but because there were so many Christmas houses, that would not be possible. And because it was a seasonal product, it's very difficult to use them in a different time other than Christmas. So regrettably, also the client regretted this. Only the destruction claim was the last resort for this specific case. Overall, I would like to finish my presentation. As I said, I think it's a very important topic. I'm glad we could discuss it, and I look forward to receiving your questions and your thoughts. Thank you very much.
Thank you very much, Jan, for your nice presentation. We have been receiving some questions that we will address it at the end of the presentation of Nuria. So now we pass the word to Nuria. Thank you.
Thanks, Jorge, for introducing me. I have a long experience in IP, not so long in sustainable actions, but from several years, I am very involved in developing a React Sustains project in Spain. So thanks to APP and to ACP for giving me this opportunity to participate in this interesting event. I'm going to share my screen. Yeah, before I would like to make a brief about the topics I'm going to deal in this presentation. I would like to make an introduction about the previous one, about who is React. I would like also to give some examples of concrete projects we have conducted this year, not only in React Sustains Spain, but also in other units. And at the end, we will give some conclusions. React is an organization with more than 30 years of experience fighting against the trade of counterfeit goods on behalf of more than 320 trademark owners. We have more than 120 offices and partners around the world, and our headquarters are based in Amsterdam. Our mission aims to provide sustainable solutions for the disposal of counterfeit goods. React activities include, as you may know, assisting in customs and police seizures. And through this cooperation with trademark owners and authorities, we contribute to seize huge volumes of counterfeit products every year. Then one of our priorities is processing these seized counterfeit goods in an environmentally friendly way. The real thing is that we should bear in mind that still today, as Leonor was mentioning at the beginning, counterfeit products are incinerated or put in landfills in most countries around the world. Incineration for energy recovery is really an exception. Even downcycling is an exception as well, and is really very rarely to have recycling cases as of today. We have to say that as of today, there are opportunities, but we have still a lot of things to do to be in a good point. Spain plays a significant role in React Sustains due to the issues we already know about storage and dismantling in Spain. Authorities claim not to have public rooms, no resources for processing all these goods, and also React defends that right owners are not responsible in the theory for this activity, we have to support it when we consider that is necessary to the aim of continuing fighting against the market of counterfeits. And which is our role? Our role, it depends on the countries. In Belgium, Turkey, and Bulgaria, we have adapted to existing practices after an in-depth evaluation. But there are other countries in which REACT assists even in transportation and find recycling partners. For this, we have appointed REACT Sustains ambassadors around the world. And in other countries, we have adopted a more active approach, as in Spain and in the Netherlands. And we contribute by assisting during the dismantling process by separating materials through social work. We have to bear in mind that I always say that REACT Sustains is not a recycling company. So our main scope is to find real recycling entities and to be intermediaries to find good solutions at a reasonable cost. We have, in fact, several partners already in Spain that are active in the recycling of counterfeit products with our cooperation. And I would like now to give some examples of what we have done this year in Spain. In March of this year, we conducted a sustainable destruction of approximately 100 tons of sneakers seized by Barcelona Customs. It was a huge intervention. And we conduct this process of separating components, the laces, the metal parts, the boxes, and the plastics. I have to say that years ago, all this material would have been simply destroyed together without any kind of separation. Even if we did it through our partner Grupo or another, but at the end, we always are present as REACT Sustains to supervise all this process. We have here some further pictures. And another example of a textile disposal we have conducted this year was recently, we destroyed 5 tons of textile at Inretex plant, that is other of our partners in Spain. All the remaining materials have been used to produce felts, and mainly for mattresses and for the automotive industry, for sound insulation and padding. So for us, this is a very successful action because, as you may know, in textile is not easy to have good solutions. So at least we can say that it has not finished incinerated nor in a landfill. So we are proud of this. This is some of the pictures we take during the process. And I am even more proud of this another example, that it was in March. Is a destruction of watches in March, and also recently 1,000 of watches that were seized by Valencia Customs. And we use 2 of our partners, Ecoalum and also Recicla. And I say that I am even more proud because it's watches. So can you imagine if we destroy all together without separating the batteries? So this is a very good point. The main issue why it has not been done before, due to the cost. You know, that's the main, because at the end, in the practice, at least in Spain, we have to make this one by one. We have to separate the battery of each single watch. So at the end, if you don't have very good partners with a very reasonable cost, it will not be possible to afford this kind of disposal. And one of the first disposal we conducted at REACT Sustains Spain was very simple, because it was these Uno cards. So at the end, we only had to separate the plastic and the cards. But it was complicated. It was complicated because it was the first one, in fact, and we had to convince authorities that the process would take longer than usual. Authorities were used to conduct the destructions in 2 hours. So, but you cannot separate plastic and card, for instance, or neither the batteries of the watches in 2 hours. So it was one of the difficulties, the bureaucratic difficulties we found from the beginning, and that we can say that along this year we have given very big steps in this sense, and we are having much more cooperation from authorities to conduct this kind of disposal activities. I would like now to pass to other examples, not in of React Sustains in Spain, but also in other React units. In particular, we have new React Sustains DWZ premises in the Netherlands for improving comfort and sustainability through features like climate control and energy efficient lighting. So we are very happy with these new premises. We have also something that it seems very simple, but it has been very, very useful for us this year, is a trinamic spectrometer, because it enabled a DWZ to assess plastics in counterfeit items. And then it helps also to improve the recycling outcomes. Why? Because it's not the same, it depends on the type of plastic, you can have different recycling solutions. So thanks to this investment, we are also having an improvement in the solutions of recycling of plastics. In addition, DWZ has supported Dutch customs with offsite destructions of seized items. And we have also cooperated with MIREC for sustainable e-waste recycling as overflow capacity. And it has been made in particular for the recycling of electronic devices. In addition, we are cooperating as React Sustains with Utrecht University students in the frame of the Da Vinci project. I have to say that for React, is one of the primary goals is investigated in solutions for counterfeit processing. As I was mentioning at the beginning, at the end, we are still at the beginning of finding good solutions, mainly due to the lack of sufficient technology, etc. But for that reason, one of our goals is to study and to invest in this field. I have here a video that I would like to share with you. I have to say that it's not of our new premises, but is a way of looking what we are doing in the practice.
The React Sustains program is meant to process the confiscated goods in a responsible manner. In the vast majority of countries, the products are simply incinerated or put into landfill sites. In our opinion, this is no longer acceptable. React is most conscious of its responsibilities and the limitation of natural resources. As far as counterfeit products are concerned, it is not possible to bring them into circulation. In fact, once seized, they must either be destroyed or put beyond use. We have to avoid any potential contribution to global warming, though. The products usually contain valuable base materials, such as plastic, metal, wire, etc. A good example of the React Sustains program is DWZ. React participates in this company, which is a social workplace. In DWZ, the workforce consists of people who are reintegrating into society and who are eager to contribute. The work in DWZ is part of their treatment and contributes to their recovery. How exactly are the counterfeited goods processed in DWZ and made unusable? And how do we prevent these goods from reappearing in one way or the other into circulation? From the customs warehouses, counterfeited goods are transported under a customs seal to the premises of DWZ. Arriving at DWZ, the seal will be broken and goods will be weighed. Each shipment will receive a unique number to ensure that each consignment can be retraced at any stage. The customs supervises the entire process through regular physical inspections and continuous administrative surveillance. After having weighed the goods, they are unpacked and instantly made unusable. That could either be done by cutting off an essential part or any other way which make the products worthless. Next step is the dismantling of the products and divide according to the commodity. Ultimately, all materials are split according to the raw material into plastics, iron, electronics, batteries, glass, paper, and so forth. Finally, the materials are weighed again, and since each product ends up entirely in a certain category, This weight corresponds exactly with the original weight of the counterfeited goods. A customs inspector finalizes the procedure by signing off a permission to destruction. Subsequently, the remaining materials are being offered to the recycling industry, which will further process the raw materials to be used for reproduction. Any other advantages? Trademark owners have to bear the cost of storage and destruction. The React Sustains program in the Netherlands showed a cost saving of 40% compared to a situation whereby the goods would have been destroyed in a traditional manner. This means more budget left to fight the trade in counterfeited goods. For customs officials, the React Sustains program means an enormous relief in having to take care of the storage and disposal of the goods. In short, the React Sustains program has lots of benefits for everyone. Society, CO2 reduction by recycling the counterfeited goods. Social hours by offering social workplaces attractive work. Right owners, a secure, responsible, sustainable, and cost-effective disposal of counterfeited goods. Law enforcement, relief of the burden to administer, store, and dispose of counterfeited goods. In all, the React Sustains program has benefits for everyone. We believe it should be embraced and introduced where possible and as soon as possible. The React
Yeah, thanks. To continue with my presentation, and we have spoken about Spain, about the Netherlands, but it's not only in these countries. I have to say that we are very active, but we are trying to reach other countries because this is a worldwide issue. For instance, I would like to give two more examples before finishing. In South Africa, we have now a recent cooperation with Allied Group in South Africa. The aim is to achieve a zero to landfill solution for counterfeit goods. React intends to fund equipment for shredding, granulating, and baling, enabling Allied to recycle these materials into building and in particular in home decor products. Allied's unique distribution through hardware and home decor stores in South African townships allows them to meet local demand while ensuring sales for recycling products. And this is a very important initiative for us, not only because we are promoting recycling, but also we are creating job opportunities for disadvantaged and disabled individuals. So we are supporting skill development and sustainability in the community. And the other example I was mentioning is in Turkey, and React Sustains launched a successful pilot project in Turkey with a new partner, Karabulut. This Tidarek is a top Turkish recycling firm that is specialized in textile recycling into fiber and machine cloth. Karabulut processes textile even from several years ago, and it has been made a sustainable destruction through separation, shredding, and refibering with non-recyclable items sent for energy recovery. So we can say that we have these conclusions. The first is that React Sustain is not a recycling company. We always insist on this. We don't have neither the ambition to become one. We fight against counterfeits, so we do not intend to be a recycling company, but we intend as primary goal to reduce counterfeit and work together with authorities and IP owners in finding the best solutions for processing all these products while addressing IP concerns, so in parallel. We consider that it's very important to bear in mind that the responsible processing reduces waste and pollution and saves valuable natural resources. So React Sustains pretends to become a pragmatic intermediary to facilitate all these responsible solutions for processing the counterfeit products. But for this, we always focus on the fact that it's essential to have volumes and support from authorities and companies. And we cannot have volumes if we don't have the support from, in particular, from IP owners. This is one of the main concerns we have. Why? Because, for instance, when we conduct the CSURs, the usual thing is that we have all the brands together, even different type of products. So if some rights owners prefer the traditional extraction and just few IP owners prefer to find more sustainable solutions, it becomes even more complicated, because it means to separate, to conduct different type of disposals of the products. So for us, it's essential to have this cooperation between all parties, the associations, authorities, and companies. Otherwise, it will be very difficult to be successful in this project. And in parallel, we need developers in new technologies, of course, to reduce costs, because with technology we will manage to reduce the cost of having all these human resources working in separations, and then this is also a very important thing, and to have, of course, the partnerships with recycling entities to do all this possible. And that would be all from my side. And thanks for attending, and thank you so much. Thank you, Jorge.
Thank you very much, Nuria. We have received some questions from the audience, so I will address them. I have here one question for Jan. The question is, how can the recycling and reuse of counterfeit goods serve as a catalyst for innovation in sustainability practices within the IP enforcement process?
That's a very good question. So what I already discussed is that if you are more conscious of the measures that you have as an IP owner, and if you not only are going for destruction, but also look at different purposes, then I think upcycling is a very interesting one that can also stimulate this process, what you talk about. It can stimulate creativity, because what you essentially do with upcycling is that you have the existing infringing product, which is unwanted, and you incorporate it into a different product, and you make a whole new product out of it. And especially in the last process, I think that involves creativity. It can add new value to an existing product, and it can mean that normally where you would just incinerate these products completely, you look for not only a different purpose, but a completely new purpose as well, that the original product, the product in which you incorporate it in, you didn't even think of. So from that aspect, I think it can stimulate creativity. It can be a new method for development that we haven't even thought about yet.
Thank you. We have another question for Nuria. What are the potential economic benefits of implementing sustainable IP enforcement methods, such as recycling and reusing counterfeit products for businesses and economics at large? You are mute, Nuria.
Sorry. Yeah, I was saying that we all need to contribute to a circular economy. We know how much damage storing and destroying goods cause to society and the planet. And then there is no doubt that an environmental disposal will generate benefits for our economy. But to be honest, I really trust that if we will encourage authority, this will encourage authorities to be more active. So at the end, one of the priorities of IP owners is to have the goods seized. And I really trust that if we give and we cooperate with this solution, it's a way to encourage authorities to act. So this is a direct benefit for instance, for the companies, you know, that, and that's, at least is my experience in Spain. I have to say that from the moment we started with React Sustains, at least for our brands, the number of seized products have really increased, because authorities have found that they have this solution. It has been, I always tell about when I started in Spain, and the first meeting I had, it was dealing the storage and destruction issue, and it was a lot of years ago. So I have to say that thanks to this project, at least in Spain, we have seen an improvement in this issue.
Thank you very much. And I will stay with you because we have another question related to these previous questions. How can companies ensure that recycled and repurposed counterfeit goods meet the necessary quality and safety standards before they are reintroduced into the market?
Yeah, Jorge, this is one of the most important challenges, I will say, because we don't have only the legal issues that Jan has been speaking about during the presentation, and that we already know this 46 TRIPS article. So this is not the only problem we have, for instance, with donation. Instead of course, the necessity of removal the logos, we have to be sure that this product is safe. So for donation is much more complicated, and in this sense, what one of our objective in the project is to find partnerships with laboratories, that they can do a test, that the product could be used safely. It's easier with the recycling. Why? Because at the end, our partners make this evaluation regarding the separate components. So if we speak about donation, we should have these laboratories confirming that the products can be used safely. And if we speak about sustainable disposal, then we trust in our recycling partners that make this evaluation of the separated components to be sure that they can be used.
Thank you. And we have here another question saying that considering that the destruction costs are high, especially when dealing with large quantities, do you see any way to charge these expenses to the infringers?
I think it's also
Is this a question for Jan or for me?
a question for me. Yeah, so that it depends, of course, in the jurisdiction where you are in. But in the EU, as I covered in my presentation, the general rule is that the cost of destruction should be for the expense of the infringer. But as this question rightfully points out, there might be many instances where the infringer cannot be found or is not solvent enough to cover those costs. So right now, in practice, at least in the Netherlands, it means that the costs have to be borne by the IP rights holder, which is, of course, a difficult situation because, as I said, they never asked for the problem in the first place, and they try to resolve it, and now they also have to pay for the additional measures. So what I would advocate is that in those circumstances where a defendant is unable to pay for it, or there is a likelihood that it will not pay for it, I think you should be able to make use of a certain scheme, a governmental scheme, where there is where there are funds reserved that you can use so that you don't have to pick up the bill yourself for destruction, because I agree that would be unreasonable. As far as I know, at least in the EU, no such schemes exist yet, but it would be something that could be considered because this will be a recurring problem. And of course, this will be the main and principal objection of right holders to say, well, I am willing to look at alternatives, but I don't think it's fair that I have to pay for them as well, or at least have to pay all of it.
Thank you. And I have another question for you, Jan. How can policymakers and businesses balance the need for stringent IP enforcement with the goals of sustainability and environmental protection?
I think it should be I think the initiative should be made with, should be taken by policymakers. They should have more guidance on what should be done in cases like these. I think primarily the claim for destruction should stay within the legislation as it is, because as I said in my presentation, there are some instances where you are left with only destruction as the reasonable alternative. However, leaving it open to national member states, or that there is a big divergence between different jurisdictions, is, I don't think, the best way forward. I think it will be up for policymakers to take the first step and have an opinion on this, also dare to take an opinion on this, that primarily destruction should be considered as the last resort, given the consequences that it may have for the environment. And if there is such guidance already, then it will be easier for the courts to use that. And also it will be more predictable for both parties, so both the IP right holder and the defendant, to know what they can expect. But foremost, it's something for the policymakers. And secondly, I think as a business as such, so as an IP right holder as such, it's a good thing if you want to be conscious of this, because you have these rights as a remedy. And you can also simply say, well, I'm not going to bother. I just want to destruction and I want to be done with it. I think it shows some awareness and some conscience if you are going to look at alternatives to destruction.
Thank you. Nuria, I have one last question for you. And it says, what are the future directions and innovations needed in IP enforcement to align more closely with global sustainability goals?
I would say advances in technologies, in particular in some fields like textiles. The requirements for recycling are very exigent. For instance, separation for type of materials and colors are often required, which is very difficult when dealing with counterfeits. You know, as we already know, the usual thing is that the products arrive of different categories and different colors, different brands. Then we really need these advances, as I was mentioning before, in technology, to avoid the costs related to the human resources. In the Netherlands, I have to say they are much more advanced in this respect, with for instance, with respect to Spain. So we hope to reach the Netherlands in a short time, but in Spain we have still a lot of things to do in technology. So hopefully.
And I have here a last question, maybe for both of you, that it's regarding the changes in the legal framework regarding this kind of new method of recycling and reuse of counterfeit goods. Do you think we need to change the law? Please, Nuria, first you. Women first.
The first thing will have to be that the infringers should cover not only the destruction costs, but also the additional cost for sustainable processing. This is, in the theory, is not necessarily a change, at least in Spain, in the law. The problems are in the practice, as Jan was mentioning, that in a lot of cases, you know, these infringers are not solvent, or you don't have any address, or you don't have, so it's in my view, it's more a practice problem. It's true that it's very different when we are dealing with customs cases than when we are dealing with police cases. It's different because with customs cases, we have DSC regulation. And then in my view, some change should be done to protect the fact that not the right owner should not cover any expenses. But with regarding market cases and the usual criminal cases, we don't need a change in this respect in the legislation. The problem is in the practice when we have now 2 cases in which the judge has ordered to the enforcement authorities to conduct these distractions, because the infringers are insolvent or in one case, and in the other case they are disappeared. And at the end, the enforcement authorities are calling us because they don't have these resources. So it's not a problem of changing the legal frame, but it's a problem that we are suffering in the practice. And I think it's in line what Jan was saying before, I think.
Yeah, so I can add to that if you look at what we have now, you can on the one hand say it's already sufficient, because there is at least under EU law, there is a proportionality test. Although I am an advocate of looking at alternative measures, I think sustainability goes 2 ways. So it goes one way towards the environment, but the other way is also it has to be sustainable for the protection of the IP rights as well. And especially for instance, trademark infringements, it is very difficult to allow a product that is confusingly similar to your own product or a 100% counterfeit product to go back to the market, because it harms the function of the trademark. You do not want that a consumer is confused by a different product and think, hey, that is your product and the quality is inferior. And for copyright owners, if you have a very special work, a very rare work. You do not want all of a sudden to have 100 identical works or near identical works to the market. So I think in that sense, it has to be a sustainable solution for the IP rights as well. But in that remit, within the interval of the two, I think there's a lot to be achieved already in the current legislation. I don't think we need to have specific, more concrete legislation in short term. What I think is that the open norms that we have now, there can be given some guidance on them. For instance, that if destruction is the measure out, then also look at a sustainable way of destroying the goods. For instance, by making use of a REACT or making use of a company that is specialized in recycling the goods or even looking at upcycling, etc. So within the open norms, I think there can be done a lot already, but we have to be careful that because they are open norms, there's not going to be a huge divergence between practices in the EU or in different countries. So overall, as I said, it's an issue of ownership at this level. It's unclear who is owning this problem. Is it the IP owner? Is it the legislator? Is it the defendant, the infringing party? Once we have that cleared out and once we are more vocal on this topic, I am sure that in the course of the coming years, there will be much more clarity and much more uniformity as well.
Jan, and I have one question. In your experience, what do you your clients, they agree in donating the infringers' goods to charity?
Yes, that works if the quantities that you seize, for instance, are relatively limited. So let's say you discover that there is an infringing product and it only consists of a stock of 200 or 300 products, then there is an alternative to sell it to charity. It's less easy than it looks like because you still have product liability questions, etc. But in my experience, you are able to come to a good agreement with a charity foundation. And if it's assured that the charity foundation itself or the recipient of these goods do not commercialize it and that they come back to the market, then I think that can be an attractive alternative. So if you have especially products that you can use as chairs or vehicles, whatever, you shouldn't really consider destruction as a main goal. They can be used better. Not always charity, because not all. I mean, you cannot give a car easily to charity, but chairs, for instance, you can give easily to charity.
And REACT, how it works, Nuria? Think the same?
Yeah, it's quite similar. The only thing in addition I will say is that in some cases donation is not possible because the product even
it will depend on the
removing
product, right?
the logos. We have had a very interesting case in this sense with bags, and it was impossible because even removing the logos at the end, the bags were reproducing, well-known models and designs, and then it was not a problem only of removing the logo, because under those circumstances the right owner, as is obvious, is not going to authorize even without the logo. So it's an additional inconvenience we have. For instance, with bags, it's quite usual that we have this issue, but with t-shirts and with these kind of things, it depends. If the logo can be removed, of course, they are available, to this solution, but with these conditions.
You still have, as I said, it looks like a simple alternative, but there are additional questions. So if you have a larger stock, transportation to the charity locations is, who's going to bear those costs? It's not always that the charity foundations do want to take those costs, and then it will be put back on the rights owner again. So it sounds like a very good alternative. I think it is, but it depends.
Yeah, and people that doesn't know about all these aside problems, like complain, why are you burning those things that you can give it to poor people, and they don't know that there are other issues involved that they must be take care about.
Yeah.
Exactly, Jorge.
Yeah. Thank you very much for your presentation and for answering these questions. If there are no more questions from the audience, we can finish, and I will pass the word to Giselle.
Thank you. Thank you, Jorge, Nuria, and Jan, for this wonderful webinar. Very, very interesting. Thank you, IPPI, for making this possible. We would like to invite you to the upcoming webinars. IPPI will have a webinar on November 12th, and it's going to be about what discovery mechanisms exist in China, Japan, Korea, and India to aid in the preparation of a preliminary injunction request or general evidence gathering. And on our side, we're going to have a webinar on November 14th. The title is Arbitration and Mediation. Are they real alternatives in intellectual property matters? For the people that could not participate today, they can find the recording of this webinar in our website or in our social media. And then we have two events coming up. On a CP side, we're going to be in Panama from the 1st to the 4th of December. Please register, and we hope you can join us. It's going to be our 60-year-old anniversary for a CP. And also on IPPI's side, sorry, on the 20 and 21st of February, we're going to have the midterm meeting, the IPPI midterm meeting in Croatia, and the super early bird starts on November 12th. So please come and register, and we hope to see you all there. Thank you all again very much, and have a wonderful day.